Welcome to the Richmond Rent Program's presentation on handling habitability problems in Richmond. My name is Nicholas Traylor, Executive Director of the Richmond Rent Program. Before we begin the presentation, there is important information that landlords and tenants should know about the ending of the state's eviction moratorium, the continued availability of rent assistance, and how the ability to evict or not is tied to applying for rent assistance. The state's eviction moratorium, also known as the Tenant Protection Act of 2020, expired on September 30th, 2021. Starting October 1st, 2021, there's no prohibition on non-payment of rent evictions for tenants who are still experiencing financial hardship. Instead of only having to pay 25% of the rent, landlords may now demand 100% of the rent. Despite the state's eviction moratorium ending, tenants and landlords may still apply for emergency rent assistance through housingiskey.com to avoid eviction. Landlords should know how their ability to evict is tied to applying for rent assistance. As I mentioned, the ability to evict is tied to rent assistance. For example, landlords seeking to evict for non-payment of rental debt that accumulated due to COVID-19 hardship between October 1st, 2021 and March 31st, 2022 must file in court a statement that before filing the eviction lawsuit, they have applied for government rent assistance, but that the application was denied. Landlords must provide to the court a copy of the final decision from the pertinent governmental rent assistance program that their application for rental assistance was denied. Landlords must also demonstrate to the court that they have not received a notice of verification from the pertinent government rent assistance program indicating the tenant submitted a completed application for rental assistance to cover the rental debt demanded. As I mentioned, before filing an eviction lawsuit, landlords must show the court that they have submitted a completed application for rent assistance to cover the rental debt demanded. Additionally, prior to filing an eviction lawsuit, 20 days must have passed since either the date the rent assistance application was submitted by the landlord or the date the landlord submitted to the tenant a 3-day notice for non-payment of rent. In addition to serving the eviction lawsuit on the tenant, also known as a summons and complaint, landlords must serve the tenant with copies of any of the required statements and final decisions filed with the court. The absence of these copies shall be sufficient grounds to grant a motion to quash, which is another way of saying that the eviction would stop or that the lawsuit would be void. Finally, the landlord must provide the court with a statement under penalty of perjury that the rental debt demanded in the eviction lawsuit accumulated under a tenancy that was initially established on or after October 1st, 2021. Now let's jump into the presentation on handling habitability problems. In this presentation, we will first do a quick overview of the Richmond Rent Ordinance. We will then go over the key habitability laws, policies, and procedures. We will then explore one of the key ways to compel repairs in Richmond, the tenant petition to reduce the rent. Next, we will examine Richmond's eviction protections and the connection between evictions and habitability issues. We will then discuss the requirement to pay relocation assistance in certain habitability situations, including temporary and permanent relocation situations. Next, we will look at landlord-tenant rights regarding a landlord's limitation on his or her ability to raise the rent or collect rent in certain habitability situations. We'll also look at the law regarding landlord entry for making repairs. Finally, we'll discuss the connection between habitability problems and landlord-tenant rights around lease breaking. But first, let's start with a quick overview of the rent ordinance. To do this, it's important to know which properties are covered by which aspects of the rent ordinance. There are three categories of rental properties in Richmond. Those properties that are fully covered, meaning properties where both rent control and just cause eviction protections apply. Fully covered properties are generally those rental units that were built with permits on or before 1995. And I should note that those are multi-unit properties built with permits on or before February 1st, 1995. Tenants and landlords in these types of properties may actually petition for a rent reduction, or in the case of the landlord, a rent increase. Properties partially covered by the rent ordinance are those where only just cause eviction protections apply and the rents are not regulated through the rent ordinance. These properties include governmentally subsidized rental units, condominiums, post-February 1st, 1995 construction with a certificate of occupancy, and properties with one dwelling unit on a parcel, commonly known as single-family homes. And finally, those properties that are fully exempt from all provisions of the rent ordinance, meaning that there are no rent control and no just cause eviction protections. Fully exempt rental units include those where the landlord and tenant share a kitchen and/or bathroom, single-family homes where a permitted ADU was added and the main house is owner-occupied, and retirement homes. The purpose of this slide is to demonstrate how properties where an ADU is added to a single-family home can fall in and out of coverage, whether it be full, partial, or no coverage under the Richmond Rent Ordinance. For example, if an ADU is added to a single-family home without permits and the main house is owner-occupied, the ADU falls under both rent control and the requirement to have just cause to evict. If both the main house and the ADU are rented and the ADU was built with permits, then the main house falls under rent control and the ADU would only have just cause eviction protections, not rent control. If both the main house and the ADU are rented, but the ADU is not permitted, then both units are subject to rent controls and just cause eviction protections. If the main house is rented and the ADU is owner-occupied, then the main house falls under both rent control and just cause, and the ADU is exempt as owner-occupied. In this slide, we're going to look at what it means when we say the maximum allowable rent. This is a term that is used when describing the maximum rent that can be charged for a controlled rental unit. The maximum allowable rent is also the agreed upon rent amount that is based on annual general adjustments added to the base amount. And there's also a possibility that the maximum allowable rent could be raised through an individual rent adjustment. The maximum allowable rent, it's important to know that the rent that is charged cannot exceed the maximum allowable rent, but it could be less. And regardless of whether the rent is raised or not, the maximum allowable rent remains the same. And we're going to look at some of the habitability laws, policies, and procedures in the state of California and locally. State law requires that a landlord provide rental units that meet certain standards for habitability. This law is also known as the implied warranty of habitability. Local housing code, in other words, Richmond Municipal Code, mirrors state habitability standards, but provides clarity and detail about those habitability standards. For example, the minimum temperature required to provide hot water. Implied in every California residential lease is an implied warranty of habitability. Landlords must provide rental units that are habitable, are in habitable condition, and fit to live in. In order for a property to be habitable, it must have all of the following, and I'm not going to go through this complete list, but for example, you have to have effective waterproofing, so there can't be ceiling leaks or roof leaks. Plumbing facilities must be in good working order, including hot and cold running water. Gas facilities must work. Heating facilities must work. The electrical system must work. The grounds of the building must be free from rubbish and trash and rodents and vermin. And there have to be adequate trash receptacles provided. The floors, stairways, and railings have to be in good repair. You have to have a working toilet, bathtub, shower, so on and so forth. Tenants also have a responsibility to maintain habitable rental units under state law. A tenant must take reasonable care of the rented property and common areas, such as hallways. This means that the tenant must keep those areas in good condition. A tenant must also repair all damage that he or she causes or is caused by the tenant's guests, children, or pets. And when I say they must repair, in many cases, they must get permission from the landlord first before making repairs, but they would ultimately be responsible for the cost of repairs. And the law that addresses a tenant's responsibilities around habitability is Civil Code 1941.2. And this law essentially, as I mentioned, requires that the tenant keep the premise clean and sanitary, to use and operate the gas, electrical, and plumbing fixtures properly, dispose of trash and garbage, not destroy, damage, or deface the premises or allow anyone else to do so, not remove any part of the structure, use the premises as a place to live and use the rooms for their proper purposes, and to notify the landlord when deadbolt locks and window locks or security devices do not operate properly. In the coming slides, we're going to discuss steps for addressing habitability problems, including tips for documenting habitability problems and how to request a housing inspection. First, let's go over key steps that should be taken to address habitability problems. One of those steps is educating oneself about their rights and responsibilities. And this education may start with a conversation with a rent program housing counselor. Next, you should document the problem by writing letters and emails, taking photos and/or videos of the problem, which all can be attached to any letter or email of complaint. If the landlord is not being responsive, the tenant may request a housing inspection with the City of Richmond. Governmentally subsidized tenants may request an inspection from the housing authority. If the property is fully covered, in other words, it's rent controlled, a tenant may file a rent reduction petition and/or request rent program mediation to encourage the landlord to address the issue. Tenants are generally advised to write letters or emails when there are habitability issues and when making habitability complaints. Attaching photos and/or videos to the letter or email is an effective way to document the problem. Expect these complaints and communications, save these complaints and communications and keep all copies of these records. If you are engaged in verbal communication with a tenant, it is recommended that you summarize the conversation in writing to avoid unnecessary disputes or misunderstandings. This, of course, goes both ways. If the landlord is not responsive to legitimate complaints, the tenant may consider documenting the habitability problem through an inspection by the city, so the city can compel the landlord to fix the problems. Using a chronological approach to memorializing the problems is important in terms of framing the narrative. In other words, if the case were to go before the rent board or the court, such chronological memorialization will help the court and or the rent board in their decision making. Be mindful that anything you write may become a part of a court action wherein you would be required to appear before a judge to explain your words and of course your actions. And because of that, it's important to be aware that your credibility is often tied to the way that you are communicating to either the landlord or the tenant. Another very effective way to compel repairs is to request a housing inspection. To request a housing inspection, you can contact the City of Richmond's Residential Rental Inspection Program at 510-690-8260 or Richmond RRIP at ci.richmond.ca.us. It's important to note that the landlord's contact information must be provided at the time the request is made. For Section 8 tenants, if a Section 8 tenant believes their landlord is violating the terms of the housing assistance payment contract or lease, Section 8 tenants are advised to contact the Contra Costa County Housing Authority at 925-957-7023. And upon determination that an inspection is needed, it generally takes about 10 days after making the request for the inspection to take place. The inspector will notify the landlord if after their inspection they find code violations, and if the landlord doesn't correct the violations within a deadline provided by the inspector, they may face fees or fines for failure to correct those violations. Another very powerful way to encourage and compel repairs or the correction of habitability problems is to file a rent reduction petition. A tenant can petition to reduce their rent if the following criteria is met. First, the landlord has to have been informed about the problems. There has to be a decrease in habitability or a reduction in space or services. And the tenant resides in a unit that is fully covered by the rent ordinance. In other words, where both rent control and eviction protections apply. Now, tenants who live in partially covered or fully exempt properties cannot file petitions to reduce the rent because these properties are not regulated. Properties do not have rents that are regulated or controlled by the rent board. Now, tenants in partially covered rental units may still request mediation through the rent program to try to resolve issues with the landlord. After filing a petition for habitability problems, the landlord and tenant attend a hearing where both parties can present their evidence. Alternatively, the hearing examiner may also opt to issue an administrative decision if there are no objections by the opposing party. The rent program hearing examiner examines evidence submitted in the petition and the opposing party's objections and hears testimony from both sides. A decision to award a rent refund or an order to reduce the rent generally occurs several weeks, if not more, after the hearing is held. Both parties may appeal the hearing examiner's decision within 35 days from the date of the decision. And if the decision is appealed, the 5-member rent board acts as an appellate court and issues a final decision, which may then be appealed to Superior Court. Many people are unaware that a landlord's ability to evict can be tied to habitability issues. Before we delve into this connection, let's examine the 8 just causes for eviction in Richmond. Residential tenants can only be evicted if the landlord has at least one of the following 8 just causes. The first is failure to pay rent. That does require a notice to pay rent or quit prior to being able to evict. And of course, the tenant must not have paid rent within that 3-day period usually. Breach of lease is another just cause. Breach of lease requires that the landlord first issue a written warning notice and give the tenant an opportunity to correct any violations that occurred. Another just cause is nuisance. Nuisance can include noise, excessive noise, not maintaining or causing damage to the property, criminal activity, and other forms of behavior. Nuisance also requires a written warning notice in most cases, giving the tenant an opportunity to correct the problem within a reasonable amount of time. Another just cause is failure to give access. Again, a written warning notice is required, putting the tenant on notice that they are denying the landlord lawful entry, and that failure to allow lawful landlord entry may be a just cause for eviction. Another type of just cause for eviction is a temporary eviction, temporarily requiring the tenant to vacate in order for the landlord to undertake substantial repairs. This type of just cause for eviction requires, in most cases, relocation assistance as required by the Richmond Relocation Ordinance. Another type of just cause is an owner move-in eviction, and that can include a qualified relative. Owner move-ins do require permanent relocation assistance be paid. Another type of just cause is withdrawal from the rental market. This is a type of eviction that is allowed under state law and under the Richmond Rent Ordinance, and it places serious restrictions on the property, including prohibitions on renting the property for at least 2 years, and in first right refusal for up to 10 years. And for rent-controlled tenants, the right to return to their unit at the rent that they were paying when they were evicted, plus any intervening cost of living increases that would otherwise be allowed. Withdrawal from the rental market also requires permanent relocation payments be made. And finally, the last just cause for eviction is a temporary tenancy. And a temporary tenancy only applies to single-family homes and allows a homeowner of a single-family home or condo to temporarily rent out their single-family home or condo for a period of no more than 12 months. And it must be put in the rental lease agreement that the tenant must vacate upon the owner's return to the property within that 12-month period. No relocation assistance is required for temporary tenancy evictions. So the first connection between evictions and habitability issues is nuisance. Now, not all nuisance relates directly to habitability problems, but nuisance certainly can be connected to habitability problems. Such problems could include abandoned vehicles on the property, maintaining, damaging the property, maintaining a filth or garbage, allowing garbage to accumulate in the rental unit or on the property. And so I bring this up because tenants should be aware that habitability problems that they cause may lead to the right for the landlord to terminate the tenancy for the just cause of nuisance. Now, if a landlord is not maintaining a property, it can also interfere with their ability to evict, but we're going to get to that in the following slides. But before we get into that issue, I want to talk a little bit more about the requirement to provide a written warning notice for certain types of just causes. So written warning notices must be served prior to a notice of termination of tenancy if the just cause for eviction is breach of lease, nuisance, or failure to give access. The notice must provide a reasonable period of no less than 5 days for the tenant to cure or correct the violation prior to the landlord serving a notice of termination of tenancy. It must state that the failure to cure may result in eviction, and it must inform the tenant of their right to a reasonable accommodation. So, for example, a tenant may require additional time to cure if they're disabled. It shall include the contact number of the rent program, and it also shall include instructions on how the tenant can be in compliance. In other words, how they can correct the problem or the violations that they have caused. And it shall also include information necessary to determine the date, time, place, and witnesses present, and any other circumstances related to the violation. So we're going to get a little bit more into the connection between habitability problems and evictions. Habitability problems can be used as a defense to an eviction lawsuit. And it's also important to note that retaliatory evictions are legal. So for example, if a rent-controlled unit is deteriorating and the landlord is attempting to terminate the tenancy, a tenant can use or may use the habitability problems that they're experiencing as a defense to an eviction lawsuit. An attempt to evict a tenant on the basis of the tenant submitting a request for a housing inspection is generally considered retaliatory and therefore unlawful. Now, another important thing for tenants to do when experiencing habitability problem is making sure that they have chronologically documented the problems. So it's important to chronologically document your response and actions taken related to habitability problems. It's also important to know that failure to address the issue may show a pattern or effort on the part of the landlord to illegally force a tenant to move out, or what is known as constructively evict a tenant. Landlords must be in compliance with the rent ordinance to evict. So the connection with habitability issues is the fact that a hearing examiner may issue a decision to refund or reduce the rent until a habitability problem is fixed. And if the landlord fails to issue the refund or reduce the rent or fix the problem, a tenant may use the landlord's non-compliance as a defense to an eviction lawsuit. So not following a hearing examiner's decision triggers non-compliance with the rent ordinance, which can be used as a defense to an eviction lawsuit. Now we're going to get into relocation payments and their connection to habitability problems. So under the Richmond Relocation Ordinance, if habitability problems are such that repairs and abatement require the tenant to temporarily relocate, the landlord must pay for the temporary relocation. In some cases, a landlord and tenant may agree to a permanent relocation payment if after the temporary relocation period is over and the tenant does not want to move back to the unit and instead finds alternative permanent housing, the landlord and tenant again can agree to the permanent relocation payment amount. So let's get into a little more detail with regard to temporary relocation payments. So temporary relocation payments must be provided to tenants when they must temporarily vacate in order for the landlord to undertake substantial repairs. A notice of entitlement to relocation payment must be provided with the notice of termination of tenancy. And the amount of relocation payment is something that is determined by resolution of the City Council. So this slide shows the 2021 temporary relocation payment amounts, and you'll see that for a hotel or a motel, it's about $162 per day. Per household. Meal expenses are $32 and some change per day. Laundry, and that's per day per person. Laundry expenses are $1.08 per day per household. And if the tenant has pets that must be relocated, the payment for that would be $31.53 for cats and $56.54 for dogs, and that's per day per animal. And the applicable amounts must be paid on a weekly basis and calculated on a daily basis at minimum. And alternatively, the landlord may provide comparable housing located in Richmond. In such case, the landlord shall provide per diem payments until the tenant and their possessions have been moved into the comparable rental unit. This chart shows the 2021 permanent relocation payment amounts. And this one is in particular for owner move-ins. As you can see, the amounts vary from $3,796 and some change for a studio all the way up to $7,982 and change for a 2-bedroom plus. And if the tenant is a qualified tenant, they have a right to a higher permanent relocation payment amount. You can see the amount is about $1,000 more for each of the bedroom types or rental unit types, and a qualified tenant household is defined as any household that includes at least one tenant that is a senior citizen, so 62 years old or over, a disabled tenant, or a tenant who has at least one minor dependent child living with them in the rental unit. Now we're going to discuss landlord entry to make repairs. Actually, I skipped one. While I was describing this chart, I forgot to mention that these payments are for withdrawal from the rental market, or if the landlord must make substantial repairs that require the tenant to permanently relocate, or if a governmental agency has issued an order to vacate, in other words, a red tag, or other conditions that are described in Richmond Municipal Code, section 11.102.030C. So as you can see, the relocation payment amounts for withdrawal from the rental market, or requirement for the tenant to vacate due to a government agency order, are higher than the owner move-in amounts, and range from $7,648 and change all the way up to $18,310 and change. Again, depending on whether or not the tenant is a qualified tenant. Okay, let's get into landlord entry for making repairs. So if a tenant informs a landlord about a habitability problem, the landlord does have an obligation to make the necessary repairs. Now, the landlord or their agents have a right to enter the rental unit to make repairs after giving the tenant at least 24 hours written notice. A landlord cannot abuse their right to enter and must follow the specific rules laid out in California Civil Code 1954. Abuse of the right to enter can lead to the landlord being unable to reset the rent to market in some cases. In other words, if the tenant is forced to vacate as a result of the abuse of entry. In other words, this could be considered constructive eviction if the tenant is forced out due to a harassment related to unlawful entry. Furthermore, California Civil Code 1940.2 allows or says that a landlord may be liable for statutory penalties of up to $2,000 per violation for committing a significant and intentional violation of illegal entry into a tenant's unit as specified in California Civil Code 1954. Now, one of the common misunderstandings about landlord entry is that the tenant has a right to deny entry if they cannot be present for the landlord when the landlord enters. A tenant does have a right to be present during the inspection, but Civil Code 1954, which is the state law governing landlord entry, does not give a tenant the right to deny entry because the tenant is unable to be present at the time of the entry. Denying the landlord lawful entry because the tenant cannot be there at the time of the entry may actually give the landlord the right to evict the tenant under the just cause provisions of the rent ordinance. So let's just look into California Civil Code, which is again the state law that governs landlord entry. So to be clear, a landlord may enter a rental unit only for in case of an emergency, to make necessary or agreed repairs, decorations, alterations, or improvements, to supply necessary or agreed upon services, or exhibit the dwelling unit to its prospective or actual purchasers, mortgagees, tenants, workers, or contractors, or to make an inspection pursuant to subdivision F of section 1950.5. Now, subdivision F is the part of California Civil Code 1950.5 that requires the landlord to provide a walkthrough inspection at the end of a tenancy when the tenant is vacating. And the landlord does have a right to enter to do the walkthrough inspection at that time. The landlord may also enter when the tenant has abandoned or surrendered the premises, pursuant a court order for the purposes set forth in Chapter 2.5, which is, in other words, for the landlord to check for water submetering, to comply with the provisions of Article 2.2 and Division 13 of the Health and Safety Code. That's to ensure compliance for patios and balconies. And to be clear again, landlords may not enter for general inspections. Landlords must give the tenant written notice to enter, and that notice must provide at least 24 hours notice prior to entry. Now, the landlord does not need to provide written or verbal notice to enter to respond to an emergency, such as fire, flooding, etc., or if the unit has been abandoned, or if the tenant is present and consents at the time of entry. The tenant cannot demand that they be there when the landlord enters. And the entry must be during normal business hours, which is generally between 8 or 9 a.m. to 5 or 6 p.m. And for showing a unit to prospective buyers or renters, the normal business hours can include Sundays, Saturdays and Sundays, when properties are being shown for sale. Now, the landlord must also state the date and time, or the time and date of entry, as well as the purpose of the entry in the written notice. And in Richmond, it is just cause to evict a tenant who denies a landlord lawful entry after the tenant has been warned to cease denying lawful access and continues to do so. Now, there are state and local laws that place limitations on a landlord's ability to raise or collect rent. I want to go through those with you right now. So in certain cases, a tenant may have a right to withhold rent due to habitability problems. Under California Civil Code section 1942.4, California Civil Code 1942.4 prevents a landlord from demanding rent, collecting rent, issuing a notice of rent increase, or issuing a 3-day notice to pay rent or quit when all of the 4 factors exist. The rental unit substantially lacks any habitable characteristics as listed in Civil Code 1941.1, or violates Health and Safety Code 17920.10, or is deemed and declared substandard as explained in Health and Safety Code section 17920.3, because the conditions listed in that section exist to the extent that endangers the life, limb, health, property, safety, or welfare of the public or occupants. Another factor that must exist is a public officer or an employee who is responsible for the enforcement of any housing law. That could be a housing code inspector or RHA employees who do HQS inspections. Now, any employee, public officer or employee who's responsible for such enforcement, after inspecting the rental unit, has notified the landlord or his or her agent in writing to abate the nuisance or repair the substandard condition. Another factor is if the condition continues to exist without abatement for 35 days beyond the date of written notice provided by the public officer or employee responsible for enforcing housing laws. And finally, the complained of condition was not caused by the tenant. Now, a landlord who violates this law is liable to the tenant for actual damages and special statutory damages of not less than $100 and not more than $5,000. Now, there's another way that habitability problems may lead to restrictions on the landlord's ability to raise rents. So a hearing examiner may deny a landlord from taking a future vacancy rent increase. In other words, their ability to reset the rent for rent-controlled units if there is evidence that there was an intent by the landlord to force the tenant out by not fixing things. Under rent board regulations, if a tenant moves out of a rent-controlled unit due to unabated habitability problems, the rent board may consider this a non-voluntary vacancy, and as a result, may not allow for resetting of the rent. If a tenant leaves as a result of the unabated habitability problems, as I just mentioned, the rent level for the next tenant would remain the same as the level that the tenant who was forced to vacate was paying. Now, another thing that's important to remember is that non-compliance, I mentioned this earlier, but non-compliance with a hearing examiner's order can also result in a denial of AGA increases. Now, AGA increases are the cost of living increases allowed annually for rent-controlled units. So if the rent board hearing examiner orders a landlord to make repairs or to reduce the rent or refund rent overcharges, and the landlord fails to comply with that decision, the hearing examiner can deny the landlord from taking future annual general adjustments until the landlord comes into compliance. Now, in this last section, we're going to examine what happens when a tenant breaches the lease or breaks the lease, and how that breaking of the lease can be connected to habitability problems. But first, let's look at the state law that governs lease breaking. That law is known as California Civil Code 1951.2. Now, if a tenant breaks a lease, they are liable for unpaid rent, but only if the landlord attempts to mitigate unpaid rent damages by making a reasonable effort to re-rent the unit. In other words, if a tenant breaks a lease, the landlord cannot make a tenant pay for unpaid rent unless the landlord can show that they've made a reasonable effort to re-rent and we're still unable to find a replacement or new tenant. Now, even if a tenant breaks a lease, a landlord may not charge the tenant for all of the rent still due on the contract. For example, if a tenant breaks a lease 6 months in, a landlord cannot charge the tenant for the remaining 6 months of rent. A landlord may only charge rent as it becomes due, during which they must continue to make a reasonable effort to re-rent the unit. So when it comes to breaching a lease or breaking a lease, significant habitability problems can allow a landlord to vacate the property without having to give a 30 days written notice. So, if a tenant vacates a rental unit due to habitability problems, they may not have to give a 30 days written notice. If a tenant vacates the property and then is sued by the landlord for unpaid rent, ultimately a tenant's right to vacate without providing notice would be decided in court. Now, significant habitability problems may allow a tenant to vacate the rental unit without being liable for unpaid rent remaining on the lease. In other words, if a tenant vacates the rental unit due to significant habitability problems, the tenant may be allowed by law to vacate the rental unit without being liable for unpaid rent remaining on the fixed term lease. Since the landlord promises to comply with or is required to comply with the implied warranty of habitability when they sign a lease agreement, the tenant may argue that the landlord actually breached the lease agreement by failing to follow the implied warranty of habitability. However, ultimately, whether a tenant or landlord is liable for breaking a lease is an issue that would be decided in court. Now, because each lease breaking situation is different, it is recommended that landlords and tenants consult with an attorney prior to taking any action regarding breaking the lease. Now, mediation is often a very good option for resolving ongoing habitability issues. Now, either a landlord or a tenant may request mediation through the rent program to resolve habitability issues. Mediations can be informal or formal and usually can be scheduled within weeks, whereas the petition process can take months. And mediations are generally less adversarial in nature, and participants often improve their relationship due to better communication and understanding. This is our last 2020 workshop. Now I'm going to quickly take you to our 2021 workshop, and let's go ahead and see our schedule for the rest of the year. So one of the things that I'd recommend landlords and tenants do is check out our website regularly. We have a lot of information about landlord-tenant rights. A lot of that information is provided through our workshops. So if you go to our webpage, which is richmondrent.org, you can access all of our workshops by clicking on the workshops link, and you can see our 2021 workshops. We do have at least one more workshop. This workshop will be performed in Spanish and should be presented December 10th. And prior to that, starting in November 19th, there will be a Spanish-only how to file a rent increase or decrease petition. Going back to our website, I just want to quickly show landlords and tenants how they can access the rent adjustment petition. So if you go down to forms, you will see that you can click on where it says rent adjustment petition. And you'll see that there are petition forms available for both tenants and landlords. A tenant wishing to file a rent reduction petition would click on the tenant petition packet, and then they would also also click on attachment B, which allows the tenant to describe the conditions they're living in and go into detail as to what their claim is. So I just wanted to quickly show that to everybody. And now we'll go back to the presentation, which is now essentially over. And let me just quickly do that. Okay, where are you? There we go. So if you have questions about how to file a petition, how to request a housing inspection, if you want to know more about how to address habitability problems, please go to our website at richmondrent.org. You can also call 510-234-RENT. Well, that's 510-234-7368 to speak with one of our housing counselors and learn more about your rights. And for those who are not aware, we also have an online appointment system. So if, because currently we are not open for drop-in, in-person drop-in, we are available for phone, Zoom, and in-person appointments, but only by appointment only. And to request an appointment, you can go to our webpage and click on the appointments link and fill it out, fill out the intake. And soon after that, you'll be contacted by a rent program staff person to schedule your appointment. And with that said, thank you very much for listening to this presentation. And again, feel free to contact us at 510-234-RENT. You can also email us at rent@ci.richmond.ca.us. Thank you very much. Hope everybody stays safe and healthy. Thank you.